We stand here as the firm of Musyoki Mogaka Advocates and have been on record for one of our esteemed clients, the Honorable Aisha Jumwa, who is the Cabinet Secretary in charge of Public Service and Gender, and was in court and has been in court accused of the alleged murder charges. And in the spirit of giving a proper defense to our client, we reviewed the evidence that the prosecution had supplied us with. And in reviewing our evidence, we are of the opinion and advice that the evidence is not sufficient to hold the charges that have been preferred to our client. In that spirit, we wrote to the Director of Public Prosecution himself, attention to Mr. Nurdin Haji, requesting, first of all, analyzing the evidence that we have in our eyes as defense counsels, and requesting that he withdraws the matter since the charges hold no water to our client. Now, the Director of Public Prosecution, under Article 157 of the Constitution of Kenya, cannot be directed by any person, but it is his prerogative and in his line of duty to assess any information that comes to him. And being prompted by the same, he consequently applied to court to have the matter to be withdrawn. We are hoping that in the light and in the long run, and in the interest of justice, that the court will withdraw these charges against our esteemed client, seeing as the Director of Public Prosecution under Article 157 can discontinue any proceeding before a criminal court, but can only do so with the permission and the consent of the court. I will leave the rest to my senior, Mr. Omayo, to address on the same.
As the defense, we have quite a number of tools on how we represent our clients. In the criminal justice system, once trial commences, the court can pronounce itself at the stage of no case to answer. That is known to the public, so that the accused person is put on his defense. However, when you look at the statutes and specific laws that under which a trial is conducted, as well as the players in that trial process, you realize that the Office of the Director of Public Prosecution has the sole mandate of commencing or taking over prosecution of an offense in a criminal trial. Equally, the ODPP has powers under Article 157, that's 6, to discontinue a criminal trial that has already commenced. And in exercising its power under Article 157.6, the ODPP first has to make an application in court and to seek leave of court to discontinue that criminal proceeding. So that court is well briefed, and that it gets to stop future abuses of the criminal justice system. Therefore, in this context and circumstance, our client, the Cabinet Secretary for Public Service, we have written to the ODPP invoking the powers of the ODPP under Article 157.6, requesting the ODPP to relook at the evidence which they have already supplied us, so that we don't have a miscarriage of justice and a waste of the court's time. Now, they are looking into the same, and we expect them to have the same before court and to be granted leave, because ideally what is before court cannot even get to the stage of a case to answer or no case to answer.
Today, the Director of Public Prosecution made an application before the Anti-Corruption Court to withdraw charges against the Deputy President of the Republic of Kenya, Honorable His Excellency Rigathi Gachagua. The court gave her an undertaking to give its ruling tomorrow. The Director of Public Prosecution has been hit hard by everybody that he is trying to exercise powers not provided under the Act or under the Constitution. I want to lay it very clear, the position to that effect. We ourselves, representing Aisha Jumwa and quite a number of people who were charged, after being given the witness statements, we evaluated the witness statements that we have of the complainants, of the accusers, to the Cabinet Secretary and very many others of our clients. With over 30 lawyers, we found out that the evidence that we have does not meet the threshold to take Aisha Jumwa or any other of our clients through the criminal process system. We did invoke Article 157, 6 and 7, to the effect that the Director of Public Prosecution, if given new material evidence that was not there, the Director of Public Prosecution has power to review. We wrote letters. I myself have written more than 13 letters on behalf of my clients, analyzing the evidence presented. The Director acts under Article 157, Article 157(11), that says it is his duty, cardinal duty, to protect an abuse of the legal process. It is his cardinal duty to protect any form of malicious prosecution that has been brought or investigation that has been brought. We invoked Article 157, 11 to tell the Director of Public Prosecution that the CS and very many others, just like the Deputy President, an abuse of the legal process is being put in motion. This is the evidence. The Director of Prosecution looked at that evidence, agreed with us, and in the anti-corruption matter that was facing Waziri Aisha Jumwa, he went to court. Remember, the Director of Public Prosecution does not terminate any matter. He makes an application giving reasons to a court of law pursuant to Article 157(8), which says he can only terminate with permission of the court. And that is what happened today. The Director moved to court in Mombasa, the way he has moved here. We have also pushing the Director to move to Mombasa High Court to terminate the murder trial for one Aisha Jumwa, because the bullet that shot the victim, one Aisha Jumwa has never had a bullet, has never run a gun. Number two, the bullet that shot is not an ordinary civilian bullet. So based on the ballistic report and based on the evidence we have produced to the Director, we are confident that the evidence to pin one Aisha Jumwa and others to continue with the matter is contrary to Article 157(11), an abuse of the legal process, an abuse of the criminal justice system. So in this one, the Director of Public Prosecution is right. If evidence has been adduced, and this appears every other time, even when judgments in civil matters have been concluded, the civil procedure rules in Section Order 45 provides for, if there is new material evidence that has been produced, the court will open up that matter and allow the new material to be brought, because the essence of a criminal justice system is justice. We have produced that to the Director of Public Prosecution. Remember, the Director of Public Prosecution does not take instructions from anybody. But on terms of withdrawal, he must get permission of the court. We are very certain in the Mombasa matter, the court is making its ruling on the anti-corruption matter for Aisha Jumwa. We are expecting the director to move to court in the murder trial so that it is terminated because the evidence does not link one Aisha Jumwa to that matter. And it is very clear that it is us advocates who have written to the Director Public Prosecution, just similar to what Gachagua did. His advocates introduced new evidence to the Director, and the Director has acted judiciously pursuant to Article 157. And we hope this settles the matter, the debate in the country, that whether the Director Public Prosecution has power to terminate matters. The Director of Public Prosecution has power to review, and once he reviews that matter, he comes to court, provides evidence, and if the court is satisfied, it is the court that withdraws the matter. It is the court that withdraws under section, the CPC section 87A, or terminates that matter. So I hope that settles the country, that the Director Public Prosecution in this matter, and on behalf of my clients and our clients, has not abused his office. Any question? If a party produces exonerating evidence, and we have provided exonerating evidence that was not available to the DPP at that time, and based on that, he has made a decision to apply to terminate, and the courts will make decisions. The responsibility of any matter before a court of law for determination of whether to withdraw, terminate, or acquit depends on the judiciary, not the DPP. And therefore, that's what we say in this matter. The DPP is perfectly right. This is produced. One person can be charged for an offense, one count. If new evidence is found, the DPP can add 10, 20 more other charges. That is how the law, the criminal law, works. The DPP will exonerate. So long as there is evidence to enhance, the DPP will enhance. And that is how people who are charged with manslaughter or attempted murder, when the person dies, new evidence comes in that now this person has died, the DPP removes the offense of attempted murder and charges that person with murder. So it is according to the evidence at that time. So one Nuruddin Haji, at the time of charging, the evidence looked like it was against one Aisha Jumwa. Now that we have provided cogent evidence, serious evidence, the DPP has no option other than to apply to terminate or to withdraw those matters. That's the position of the law.